Hello, everyone, and welcome to the Restorative Justice State Policy Briefing from the Democracy Policy Network. I am Pete Davis, the director of the Democracy Policy Network. We are an interstate policy network that works to empower people to raise up promising ideas for deepening democracy. You can learn more about us at the very easy to remember URL, if you know our name, democracypolicy.network. That was me introducing myself. If you want to introduce yourself, please do so in the chat. It'd be great to hear where everyone is coming from. There are 40 states represented in our RSVPs, 200 state leaders and staffers. So it's very encouraging to hear from all the states where people are interested in restorative justice to show each other that you are not alone in advocating for this important alternative. This event is very special because we believe this might be one of the largest interstate meetings of state leaders interested in restorative justice policy this year. We're so glad to have you all here. There's been, the reason we wanted to put together a kit on restorative justice state policy and put together this briefing is there's been a good amount of talk in at least circles who care about these issues about restorative justice in the abstract, like what the alternative means. There's a good amount of talk on how to implement it in a really nitty-gritty way on the local level, in your school, in your community, but there's still underexposed the question of what can we do at the state level for state leaders, governors, state legislators, state senators, states attorney general, state folks that are running education systems and the court systems about implementing this alternative. And so we are excited to change that today by having legislators, advocates, and experts who have promoted this idea and this alternative in the past years to share their ideas with you. A few notes on how we're going to do this and how we do these briefings with Deepen, the Democracy Policy Network. We keep live notes for you as we're doing this, and we're recording this video, so you can go back to our live notes and recordings at democracypolicy.network/RJ briefing. The same place where you signed up for this, we will put the live notes and the video eventually. And if you want to champion restorative justice in your state, we are here to help get you in touch with these experts and advocates to share your interests, and we're going to give you a chance to do that. And if you want to support Deepen's work, always, we need all the help we can get. democracypolicy.network/support. We're a ragtag team of folks raising up ideas for deepening democracy in the states, and we could use any help. So without further ado, I want to throw this to Berko, who put together our restorative justice policy kit. That is what kicked off this briefing today. I want to shout out this amazing kit before I hand it over to him, because I want to sing his praises because he's too humble to sing his own praises for this kit. This is a comprehensive kit of everything you might need to know to start championing restorative justice in your state. It has access to the experts you can talk to, the elements of what goes into a good restorative justice policy, precedents of where it's been tried before, many of which will be talked about today, further reading on interesting readings on this, model legislation, an introduction that orients you to the problem, to the challenge of restorative justice. So if you go to democracypolicy.network/restorative justice, you can read Berko's kit. But we're going to have a taste of what this kit's all about with this event today. So without further ado, let's throw it to Berko. Thank you.
All right. Thank you, Pete, for that. And hi, everyone. I'd just like to reiterate Pete's welcome and excitement at being with all of you here today. So I'm Berko. I'm the policy organizer who worked on Deepen's Restorative Justice Kit. And I'd just like to add as well that that would not have been possible without the help of many of the speakers we have here today, and so many others who weren't able to make it. So just to orient today's briefing, hopefully a bit, as you're all likely aware, the current legal system fails to address the needs of harmed parties, offending parties, and communities writ large. States spend billions each year maintaining their penal systems, and yet harmed parties aren't healed, offending parties aren't reformed, and communities aren't restored. So the evidence is clear that the current criminal legal system is ill-equipped to address interpersonal, much less systemic harms. A greater integration of and financial support for restorative justice processes throughout the criminal legal system, however, has the potential for transformative change. So restorative justice refers to the reconceptualization of crime as harm between parties instead of as an infraction against the state. Taking many forms from victim-offender dialogues to community conferences, this approach to harm rejects retribution and instead acknowledges the diverse needs of harmed parties, offending parties, and their communities alike. Restorative justice is not a new idea, either abroad or at home, and hopefully today's briefing and today's speakers will help to illustrate that. States like Colorado and Vermont have implemented statutory support for restorative justice interventions as an alternative to the traditional criminal legal system. And such policies range from increasing opportunities for restorative justice diversion pre-arraignment or pre-trial to funding existing community-based organizations that are currently engaged in this work. Today, the very presence of each of you at this briefing represents an exciting next step in charting alternative and restorative ways of addressing harm and accountability within our states and without the social, financial, and moral costs of our current system. We have an amazing, thoughtful group of speakers who are gracious enough to share their time and experiences with us today. And I'm confident that the wealth of information that they share will help all of you on this endeavor. But anyway, that's enough from me. And so I'd like to turn it now to our first speaker, Ms. Sharletta Evans. Sharletta is the executive director of the Colorado Crime Survivors Network, and her life story is a testament to the power of restorative justice in practice. Sharletta, the floor is all yours.
Thank you. Good morning, Inc., and good morning to everyone, all the faces I could see, as well as familiar faces. Good morning, and thank you for the invitation. I am present here in Aurora, Colorado, and my name is, again, Sharletta Evans, and I am the mother of Kason Xavier Evans, and also the mother of Calvin Hurd and Raymond Johnson. This morning, I would like to share what really sparked my interest and really got placed my pretty much my path on the quest for restorative justice. 26 years ago, I lost my 3-year-old son to a tragic drive-by shooting here in Denver, Colorado. And in the process of losing my son, with a chain of events taking place, it so happens that it was 3 teenagers that took the life of my son. One 16-year-old that was actually the one that pulled the trigger that claimed my son's life. 2 of the juveniles were sentenced life without the possibility of parole for the death of my son, Kason Xavier Evans. And the driver was sentenced to a reduction of sentencing of 10 years. In that process of time, I wanted to be present for my son. I had accepted the call of duty as a Christian to forgive those boys that took the life of my son. And in that process, and laying eyes upon those boys when they were apprehended, seeing that they were babies, that they were simply kids that was given a lifestyle that they were not able to evade or avoid because they grew up in it. And in that process, years had went by, and I wanted to have a dialogue with the main shooter that took the life of my 3-year-old. And beginning in 2009 and working with Mr. Pete Lee that had, and his wife, Lynn Lee, that had became a legislator in the state of Colorado, and we began to do the work. He executed a bill and asked me as a victim family member to come along and testify concerning what we need as victim families. And in that process, there it was, a bill signed into law in our state for restorative justice, which opened the door for me to go into the Department of Corrections, Lyman Correctional Facility in Denver, which was a first and unheard of, but very large requested process to be at the Department of Corrections as a victim family confronting their offender. And so here we were there, a pilot program approved that I was able to sit across the table from the boy, now man, that killed my son. And we had an 8-hour dialogue. And in the process of that dialogue, we unpacked so many questions. And I was able to find out what happened that horrid night that he was out, broke in a home, stole a car with his other gang member friends, and was striking out against a rivalry gang members. 21 bullets were fired, and my 3-year-old son's brainstem was shattered that night, where he died in my arms, where he bled out all over me. And I was able to express all of these things to him, the harm he caused me, the harm he caused the community, as well as my family. And he left a hole in the soul of my surviving son, which was 6 years old at the time. And due to that horrific act, my son dealt with childhood trauma issues into his teenage and adult life. We were able to unpack all of those things there in that 8-hour dialogue. And when I left that dialogue, I had accepted this young man as my son, and my surviving son in turn accepted this man as his brother. And we were able to establish a relationship. And come Monday, which is May 23rd, is the 10th year anniversary of that dialogue that we've had. And there was a tremendous amount of advocacy work all the way to the US Supreme Court that I was really burdened to do, and go to the US Supreme Court and submit my amicus brief and bring that argument forth regarding the resentencing of juvenile lifers, to where it was awarded that it was ruled that it was something that we were able to do away with, which gave Raymond Johnson, the offender, an opportunity to be resentenced and released from prison. And he has been released for 5 months now. And he is truly a fine young man, released into society. And he is a part of my family now. So I wanted to share that much of my story. It's very intense, very, there's so many parts, moving parts and extensions and chapters to my story. But I will stop right there and give thanks to those that invited me to share.
Thank you so much for sharing your story, Sharletta. I'm sure I'm speaking for all of us here when I say that it's very powerful, and we really appreciate you giving that testimony. As Sharletta alluded to, for Colorado attendees, her organization, the Colorado Crime Survivors Network, is organizing a restorative justice high impact celebration in Aurora, Colorado, I believe, this upcoming Monday. And so another one of our speakers here, Senator Peely, is also going to be there. So, you know, we might as well make it a whole Colorado party there, and everyone should sign up, RSVP, and show face there. The event flyer is shared on the Deepen Twitter page and will also be linked to our live notes. So definitely sign up if you can. At this time, I also want to mention, if you have any questions you'd like to put in the chat, feel free to do so. And when we get to our Q&A portion of this briefing, we'll hopefully get to your question. So moving on to our next speaker, Dr. Shannon Sliva. She spent years cataloging the effectiveness of restorative justice processes. Shannon conducts research on restorative and collaborative approaches to justice, which challenge the current criminal legal model. And she's partnered with Colorado practitioners, policymakers, and advocates to document the impacts of leading edge restorative justice laws and to develop policy recommendations. So I'll turn it over to Shannon.
Thank you so much. Yeah, I've been lucky many times to get to hear Sharletta's story. And I think that it was hearing stories like that that set me on the path of my career that's focused on examining the impact of restorative justice, both practices and policies, and thinking about how we can better expand access to restorative practices in our communities based on the impacts of those. So I think my task for today, my contribution is just to share with you from a broad view about the scope of what the research says about restorative justice practice, and then a little window into policy. A lot of times we talk about needing more information to understand the impact of restorative justice, but there are more than 85 published academic studies and 4 meta-analyses, which are studies that look at multiple studies to examine themes across them. And these are all focused on different types of restorative justice dialogue and outcomes of those dialogues. So look at things like community conferencing, victim offender mediation, victim offender dialogue. And they really show similar findings across practices that we can draw from. So it's a pretty compelling body of evidence despite the few limitations that I'll talk about. In addition, because restorative practices are most commonly used with juveniles who have committed more like first-time or minor offenses in the United States, that's also the most common group that's represented in the literature. And we really need more research on other types of cases, but there's still enough for us to draw a lot of conclusions about the impacts of restorative practices. So what we learn from this body of research is that 80 to 90% of participants, and that means both crime victims and people who are responsible for causing harm, express satisfaction with the process, high levels of satisfaction. Also, the agreement rates or the completion rates of agreements that they make are much higher than those for agreements that are formed during traditional mediation or restitution, like court-based restitution processes. So people who go through a restorative process and come up with a community agreement together are way more likely, 80 to 90% more likely to complete their agreements. Whenever we compare people who are going through a traditional court process, those who are engaging in restorative justice become more satisfied with the court process and with the criminal legal system, with their experience in the system. So they're just more likely to feel that they have a sense of justice. I think one of the things that's been most significant to me is understanding the impact of restorative justice on crime victims in a more qualitative way. And I think some of the things that you heard in Sharletta's story are things that have come to bear in research, looking at victim offender dialogues and the impacts of other processes, which are that restorative processes can decrease feelings of fear, anger, depression, desire for revenge, and can even decrease post-traumatic stress symptoms and other mental health symptoms. And they can overall decrease the long-term emotional impacts of crime for crime victims. For people who have been responsible for causing harm, it can allow them to have greater involvement in the process, allow them to better make amends, and just provide them an opportunity to repair harm and help the victim and themselves heal. A couple things that I just want to point out as I close in terms of limitations of the research are that while we understand a lot about how beautiful restorative practices are and the impacts for individual participants, we're still trying to learn about impacts at the policy and system levels. So what I mean by that is that as we, in Colorado, you're going to learn today about extensive legislation that's been passed here. to support the use and expansion of restorative practices in the criminal legal system. And we're still trying to understand what's the effect of that on things like filing rates, incarceration rates, racial disparities in the criminal legal system, and other indicators of the size, scope, scale, and equity of the criminal legal system. So we know a lot about interpersonal outcomes, but not so much about how we can influence systems by using these processes more broadly. And that's something that I'm really eager to continue to learn more about. So I would just close by encouraging those of you in the room who are looking at supporting, advocating for restorative justice policy, or working on restorative justice legislation as a legislature, that one of the most important things you could do as you attempt to forward restorative justice through legislation is to account for data collection and reporting about the impacts of things that are implemented in these settings or through legislation, so that we can know what to share with other states and communities going forward. So I'll leave it there, but I'm happy to answer questions. I'm happy for people to reach out to me with additional questions about practice or policy.
Thank you so much, Shannon, for sharing and for all your work documenting the power and impact of restorative justice. Despite these processes' proven effectiveness, however, access to restorative justice processes is often limited, disincentivized, or otherwise impeded by many state statutes. Our next speaker, Professor Thalia González, will be outlining many of the practical legal barriers to widespread use of restorative justice processes in our current legal system. Thalia is a nationally recognized expert in the field of restorative justice and has over a decade of experience in law, policy, and practice. She's currently a senior visiting scholar in the Center on Poverty and Inequality at Georgetown University Law Center, and she leads the center's national research on restorative justice policy and practices. Thalia, could you speak on some of these obstacles to restorative justice in state law?
Sure, thank you. And I'll just introduce myself as well. So Thalia González, it's wonderful to join. I think like Shannon and many others in this conversation, there's a personal connection to how we think about restorative practices and why both having it as in the context of a structural intervention, right, to the last point that Shannon was making, like how do we disrupt systems? How do we think about changing, right, the political, the social, the economic conditions in which people exist, especially when we're talking about racialized disparities, but really from an intersectional perspective, you know, as the niece of a lifer and the sister of a system-involved brother who walked him through that, coming up a school-based arrest when he was only a sophomore in high school. I think I'm very thoughtful and keen as to sort of what that was in my own trajectory of ultimately going to law school and then becoming an academic, but more importantly, how and where we think about restorative practices from both that inter and intrapersonal standpoint, as Shannon was pointing out, and what the research tells us, but then how we think about really what it means from a reform standpoint in the context of what conditions are. You know, how do we really target risk factors and think about the relationships between different determinant systems. So I think I was tasked to talk about the laws in some ways. You know, I broke my thoughts into two areas. I think that we have questions relative to access. So, you know, and again, and I think Shannon queued this up for us, how do we think about increasing access? If we know restorative practices have a positive set of outcomes, even if we haven't fully explored what those all are, how do we ensure that access is available? But then what are the complementary protections that we want to ensure exist if we are going to increase our scheme? So at a baseline, I will say that, you know, even in differentiations in terms of coding, from a more research standpoint, the text of laws and what practices are, I think it's fair to say that we have, at least at a state level, developed a pretty comprehensive restorative justice scheme. Now, when I say comprehensive, that doesn't mean that it's necessarily comprehensive everywhere, and that doesn't necessarily mean that there aren't large places of opportunities for improvement. But right now, you know, we're sitting in the United States with 266 laws just in the criminal legal system. That doesn't talk and think about within education and in child welfare systems as well. And that represents 46 states and the District of Columbia. So when we're sort of thinking across the country, right, there really has been a rapid growth and an increased attention, and that has been codified formally into law. Now, what that means when it translates to the ground, of course, as all of you know, are very different things, but there is something that's important at having this as a baseline element integrated into legal structures and systems, from whether it be signaling, right, the importance of it, or actually setting up the infrastructure. And so that being said, you know, there was something that Shannon started with, and that we see a distribution that is differentiated. By that, I mean that we still do privilege juveniles in law relative to access to restorative practices. So the comparative on that is, you know, there are 91 laws across the country that specifically create access points for juveniles across 33 jurisdictions, both states and the District of Columbia, as opposed to 42 laws for adults. And then when you think about that and disaggregate it even further, for juveniles, most of that sits at early stage, or what I would call upstream. So in diversion in some form or fashion, maybe that's pre-arrest or post-arrest or pre-charge, that comes with a whole host of eligibility and selection criteria, which I'll come back to in a minute. But really for adults, it sits actually at the post-adjudication stage. So the ability to access restorative practices at an upstream or early stage intervention point, which when we think about the purpose of, quote, diversion, either restorative or non-restorative, we know that's where some of our most significant returns of investments are when we think about both individuals, but from a societal level. Like, we want to stem, or I would argue eliminate, right, the criminal legal system's focus on carceral policies that lead to mass incarceration. And that's true whether we're thinking about this from a more traditional cost-saving standpoint, or we're really keen and have our deep attention to the systemic injustices and the deep-rooted anti-Blackness and racism that exists within our carceral system and mass incarceration. We still do sit in the United States in the privileged position of incarcerating more people than any other country in the world. And that is deeply problematic, right? And that has a whole host of collateral consequences by being in what I would argue is a continuum of the criminal legal system. It's not just that incarceration, right, and confinement is where we see a whole host of economic, social, and health harms, but it's really along that whole continuum, right? And we think about that state structured violence. So if you're targeting, right, within your own state policy activity, there should be a really keen attention to thinking about increasing access for adults. And that doesn't mean getting rid of some of the categorical exemptions for certain sets of serious and sensitive crimes. But what it does mean is opening up opportunities for what people will define as sort of lower level offenses or more minor offenses, or offenses that we know are also deeply racialized and biased, right, and that shouldn't actually exist as far as criminal behavior, and having opportunities for the restorative interventions to exist at that point. You know, I think the other thing to point out, and this is actually in the kit, is that there is a growing body of use of fines and fees to access restorative practices. And I cannot emphasize enough, right, the troubling nature of that, but also what the economic collateral consequences are. There's been an incredible movement across the country for more than a decade to eliminate fines and fees within the criminal legal system, because we know how detrimental they can be, and they can create a cycle of poverty, which then also reinforces continued deepening system engagement in the criminal context. And so removing those barriers, I think, is incredibly significant. Another thing that when we're talking about access, right, is that we really have to start to become attentive to bias. You know, just because we call something restorative doesn't necessarily mean, right, that it is one, but more importantly, that everyone's getting access to that, quote, restorative option. So having restorative practices embedded into a legal scheme, into a district attorney or prosecutor's office, depending on the jurisdiction and the ways in which you name things, or even in the community context, we need to think about what are the eligibility criteria, right? What ultimately becomes the selection criteria? There is unfortunately, Colorado, I'm sorry to say, there is preliminary data, right, that shows that there is a racialized distribution in that Black youth are being referred at lower rates than their white peers relative to the most recent reporting on some of the pilot data with referral rates into restorative justice diversion. Now, I pick on Colorado because literally nobody else is willing to report their data. So thank you, Colorado, for being transparent. But to the extent, right, that is not an aberration. When I meet with colleagues across the country, we're seeing that same type of data. It's just not publicly available. So we really have to have the same attention that we have in non-restorative contexts around the criminal legal system about what is bias and where is bias along that continuum integrating, and especially when we're becoming more attentive on an intersectional level, right? So when we talk about Black girls, are we really thinking about adultification bias? How and where are they being treated as older, right? Assumed to be more highly sexualized, right? All of these performative ways in which we're holding them against a contour of white femininity that is increasing, right? Both of violence and harm that's being perpetrated against them, but movement deeper into the system. And I'll close then thinking about where are some really other targeted areas that are around protections, because I know that that was also an interest, right? So confidentiality protections are really significant. You know, at this point, we're now up to 20 laws across the country in 12 different states where we have limits on the admissibility of what ultimately can or cannot be used in either the current process and proceeding or subsequent processes and proceedings. That is a very low number, right? 20 laws. And of those 20 laws, some of those actually require a waiver of rights that does allow what is said in the context of a restorative process, a conference, a mediation to be used actually in a particular proceeding. If that doesn't reach an agreement or there is, ultimately it doesn't move forward. And so having that real clear sense that if we're going to embed this in our criminal legal system, we also need to have the same protections that exist if you're going through a non-traditional or if you're going through a traditional process as opposed to a restorative process. The same is true then when we think about the importation of other protections. So due process, right? Right to counsel. So for example, in Florida, juveniles actually have to waive their right to counsel for purposes of engaging in a restorative process. And so how and where do we think about the limits of that? Sort of what is the waiver for? You know, why do we have a right to counsel in this country? What's so important about it? And ensuring that some of those elements there. And I'll close with the last thing, which is to say there's, you know, at this point, there's not a knowing requirement. So right now for plea bargaining, for example, right, we have to have a knowing and intelligent waiver requirement to really ensure that there's not coercion that's occurring in the context of waiving your right to say, go to trial. So as much as we might want to have restorative options available, if someone is being coerced into what that restorative process might be in lieu of or instead of a traditional moving forward in the criminal legal system, we don't want to have that coerciveness exist, right? That's counter to both the principles and foundations of restorative process, but I would also argue, and I think probably others would agree, it's counter to what healing, right, and transformation looks like. So that's a little bit of a snapshot of where we are in the States, some of the key things that we should think about in the future, and I'll yield the floor to others. So thanks for having me today.
Thank you so much, Thalia, for that extremely helpful and sobering overview of the legal barriers and other barriers that we have facing restorative justice. Hopefully having this clear view of the current landscape will just help all of us to move with some more intentionality as we go about trying to implement these policy reforms in this space. So speaking to how we might design policy advocacy around restorative justice reforms, we have Jessica Persaud, the Director of Policy for Common Justice. In this role, Jessica manages the organization's policy and campaign work to advocate for racially equitable, survivor-centered legislation aimed at increasing resources in Black and Brown communities and decreasing the use of incarceration and the criminal legal system more generally. Jessica, could you speak on what effective advocacy for restorative justice policies has looked like in your experience?
Yeah, definitely. So thanks for having me. As said, I work for Common Justice. We are a New York-based alternative to incarceration and victim service program that's based in Brooklyn, and we also have offices in the Bronx. We operate the first alternative to incarceration, well, one of the first alternative to incarceration in the nation to focus on violent felonies in the adult courts. And I mention that because it's very important, because a lot of the restorative justice models, when we first put it on the scene, address low-level offenses and drug offenses because it's more digestible. But a big principle and foundation of common justice is noticing that if we want long-lasting, high-level change, we have to address and contend with the problem of violence in our communities. And that requires addressing violent felonies and more of the heinous crimes that occur. So that being said, our policy department is fairly new. We're about a year old. And when we started building out what we wanted policy to look like, as informed by our direct services and this model and that principle, we had to really understand what was the best way to push forward these practices. And those discussions really looked like, because initially, every time that people hear about restorative justice and also hear about common justice's amazing model, they're like, let's centralize it. Let's put it at the top. Let's put it at the macro level, implement it nationwide, statewide, citywide. But the problem is, and a lot of people that work in this field understand that it's not a one size fits all. It's really community specific. It really has to address the needs of the community there, the people that are involved, the people that are harmed, and also most importantly, it has to be administered by the community. It can't be administered at top level by someone who doesn't really understand the needs our minds go to that immediately because that's the status quo currently and the way that the current criminal legal system is administered. So that being said, we moved away from that and be like, we can't touch that right now, but what are other ways that we can promote these practices? And we found that because our criminal legal system across the nation is so, for lack of a better term, terrible right now, there's a lot of barriers to restorative justice. So Common Justice Policy Team organizing and all of us have really taken on the feat of breaking down the barriers to restorative justice when we're trying to implement these practices. So what I mean by that is, first and foremost, decarceration efforts. We have to reduce the amount of mass incarceration in New York State specifically, but I think we all agree across the nation. Two, we need to increase resources in communities. We all know that the most violent communities are the ones that lack the amount of resources that are necessary to stabilize communities and promote healthy communities. And finally, breaking down the barriers to rehabilitation. So post-incarceration, really having people have access to employment, to housing, to other resources that are going to help them stabilize and be productive members of society so that their lives aren't defined by the crime and the harm that they allegedly committed. So based on those principles, Common Justice focused its policy initiatives on its first year on reforming New York State's victim compensation program. And for people that aren't aware of what, or less familiar with what victim compensation is, it is funding that survivors of crime can be reimbursed for costs associated with the crime that they experience. Those costs can be medical expenses, relocation expenses, replacement of essential personal property, things like that, anything that can help stabilize someone who has experienced harm. But unfortunately, in many states and definitely in New York, there's a lack of access to that funding for multiple different reasons, but principally because there's a threshold requirement that survivors must report their harm to police and also be forced to be involved in their own investigation of that crime to really perpetuate the criminal legal system. And this is problematic in a lot of ways because several marginalized communities, particularly those members of Black and Brown communities, don't feel comfortable interacting with law enforcement for multiple reasons, distrust in law enforcement, fear of retaliation, and I mean, just the general suffering that comes after you experience this harm. It really shouldn't be the first step in what you're doing to try to achieve healing. And nationwide, I mean, the numbers really reflect this. Each year in the nation, over 50% of violent victimizations go unreported for all of these different reasons. So all marginalized communities, and as we know, these marginalized communities are the ones that experience violence at higher rates, are not getting the resources that they need to heal and thus break these cycles of violence that we find in the community and that are really necessary to promote public safety. So all that's to say, in New York, we started the Fair Access to Victim Compensation campaign to remove New York's law enforcement reporting requirement from the victim compensation program and really promote a more trauma-informed process when distributing healing funds, and really on a higher scale, decoupling law enforcement from victim services, which will essentially remove that centralized nature of the criminal legal system and really focus on the individual. And I'm happy to answer any other questions, but that's the work that we're doing.
Thank you so much, Jessica, for sharing all that. Yeah, it's very, very helpful, very insightful on how we can start thinking about how we can put community first in how we think of justice really and accountability more generally. So I'd just like to emphasize it again at this time. If you have any questions, feel free to shoot them in the chat. Speakers can also answer questions in the chat as well, feel free to. And if we're not able to get to your questions either through the chat or through Q&A, I will be sure to connect any of your questions with some of the panelists that we have here today to make sure that you get some sort of response. So for our next speaker, they are a longtime legislative champion for restorative justice, Senator Pete Lee. Senator Lee has spent years advocating for restorative justice in the Colorado State House, and he's been instrumental in passing legislation that's increased opportunities for restorative justice diversion, funding community efforts at crime prevention, and establishing a statewide restorative justice council. Senator, could you speak for a few minutes on some of these efforts, as well as the obstacles and other considerations that have come with them?
Sure, thanks, Ink, and thanks for putting this together, bringing all these people from around the country together. I've at the outset have to acknowledge Sharletta Evans as one of the catalysts who we held hands with from the beginning. And without her compelling story, her rich advocacy, and her passionate commitment to restorative justice, I don't think we would have made the progress that we had. So we've been reasonably successful in passing bills in Colorado, though somewhat less successful in getting full buy-in and implementation of restorative justice. And whenever I get sanguine about our accomplishments, I listen to Thalia González telling me the challenges that lay ahead for us. So thank you for your sobering words. So I came to the legislature after serving many years as a criminal defense attorney and recognizing that the criminal justice system did not work. It didn't work for defendants who had a revolving door. It didn't work for victims who were often marginalized and ignored. And it didn't work for the community to keep it safe, because 50% of the people who went into prison came out 3 years later, within 3 years, went back to prison. So it wasn't really contributing to community safety. I became an advocate for restorative justice, having worked in a juvenile program in Colorado, which was one of the first restorative justice programs, Workout Limited, it was called. And we had kids actually go out and work to earn the money to repay the victims of the crime. And we actually had the kids turn over the checks to the victims of the crime. It was sort of a rough form of restorative justice, but from a practical standpoint, it showed me the impact of how taking responsibility made the significant difference. When people become accountable, that becomes a transformational factor. So I began on this quest to implement, somewhat naively, restorative justice in the juvenile and adult systems in Colorado, and had a comprehensive omnibus bill to put restorative justice in the juvenile system, in the adult system, in the Department of Corrections, in the Division of Youth Corrections, and in the schools as an option, as opposed to expelling and suspending kids. School districts around the state had the option of developing restorative justice processes. So with that foundation, in that initial bill, we set up a statewide restorative justice council with stakeholders from all areas of the education system, the human services, social services systems, the criminal and juvenile justice services, to serve as a central repository of information for education and to make people aware of it. A couple of years later, we set up a dedicated funding stream by imposing a $10 fee on all criminal cases, since eliminated Thalia on all juvenile cases. So we don't have fees and fines on juvenile cases anymore. But the adult surcharge brings in about $1 million every year to the state of Colorado, which is under the auspices of the State Restorative Justice Council, who then does a extensive grant making process to enable local community-based organizations to set up or further or increase or expand their restorative justice programs. I absolutely believe what Jessica Persaud is saying is that justice needs to be community-based. It doesn't work if it's prosecuted from the top, and it needs to be based on the community. So these grants to local organizations to have restorative justice programs has really been, I think, a significant factor in populating communities all over the state with robust restorative justice programs. And I would say having the council and that dedicated fee were primary, but we also set up like mandatory advisements in statutes. So when kids or adults appear in front of judges, they're told not just, these are the charges against you. You have a right to counsel. You have a right to confront witnesses. You have the opportunity to have restorative justice as a available opportunity. I tried this year to create a right for restorative justice that would elevate it, but for a variety of reasons, we got sidetracked on that. But I think that's a possibility that other states ought to consider, is to create an absolute right to restorative justice. Because unfortunately, people that are in the institution of criminal justice are resistant. And I'm referring to district attorneys who seem to be more set on prosecution and sentencing rather than diversion and deflection. And they apply their draconian policies to everyone. I wanted to see restorative justice as not as an alternative, exclusive alternative to prosecution, but in some cases as an adjunct along with prosecution. And that would seem to be a transition position to take. So, we have a long way to go. We have a lot of opportunities for restorative justice in Colorado, and we need to keep working to expand the reception and acceptance of restorative justice. Another bill that you had asked me to talk about was our Transforming Safety Justice Reinvestment Initiative from a couple of years ago. And it was a bill that basically arose out of community. We took $5 million out of the Department of Corrections budget and set it up to make it available to local communities to utilize to get out in front of crime. We set it up so that communities, and specifically Southeast Colorado Springs and North Aurora, which were two communities that had been significantly impacted by over-policing over the years, were identified as the targets for the justice reinvestment money. They would have weekend meetings where people from all around the community would sit down and describe what is causing crime in the community. And, it's no secret to anyone that what they come up with, lack of jobs, lack of opportunity, education, lack of things for kids to do. But they also came up with some pretty unique ones, like violence in the home and things of that nature, when they came up with their whiteboard list of priorities, they would then have the nonprofit organizations submit a request for proposal to address the community identified problems that were causing crime in the community. So over the past 4 or 5 years, we have invested some $50 million into community-based organizations to address these root causes of crime. So I think these transforming safety initiatives have had a significant impact. Unfortunately, somewhat difficult to measure in some cases, but if you want to know more about it, it's the Colorado Criminal Justice Reform Coalition Transforming Safety website can tell you all about it. So that's a introduction to some of what we've been doing here in Colorado.
Thank you so much, Senator Lee, for sharing. Colorado's work in this space, as you can probably tell by now, has definitely been an example in this field, and hopefully one that other states can learn from and build on as well. However, even the best designed statutes, as Senator Lee sort of alluded to, however, need to be implemented. And so to speak on how restorative justice policies operate in practice in the state, we have Liz Porter-Merrill, the public defender representative on Colorado's Restorative Justice Council. In addition to their role on the council, Liz regularly facilitates high impact dialogues, community group conferences, as well as circle processes for community building, for racial justice learning, and to support people impacted by the criminal legal system. So Liz, could you speak to your experiences on the council and how it interacts with other actors in either the restorative justice or criminal legal spaces?
Yeah, absolutely. Thank you, Ink. Yeah, so I am the public defender representative on the RJ Council that Pete was talking about, Senator Lee, sorry. And there's 19 members on this legislatively created Restorative Justice Council that I believe was the first of its kind, a statewide policy RJ entity. And one of the challenges is that many of the folks on the RJ Council, including myself, are for seats based upon system level like agencies. So a district attorney, a judge, a public defender, public probation, you know, different system-based entities. And then there are 6 seats or 5 seats, I apologize, that are practitioner-based, practitioners on the RJ Council. And what I am noticing as a member, I've been on the council since 2015, is that there are a lot of folks who still have carceral values and orientations that are appointed to the RJ Council. And then that causes conflict within the council itself around how do we move forward in a restorative way. But I think that's really emblematic and illustrative of what we're dealing with in our culture, in our communities, in our society, right? One of the things I really wanted to highlight that I think has been great success of the RJ Council. So the RJ Council gets fees from convictions, not just a case. So what's interesting is the juvenile pilot study that Shannon and Thalia referred to was actually a diversion program for juveniles. So no adjudication, no conviction, and it was being funded by people who had convictions on their records, kids who picked up adjudications. Then that was my first clue, like we got to figure out something different with this funding. So I really appreciate and highlight what Thalia was saying. We need to figure out how to do this in a restorative way, which is sort of the theme of all of my work at this point, is like revisioning my work as a system actor, as a public defender, as an advocate through a restorative lens, and really leaning into those restorative values and practices so that because I know that the adversarial system doesn't work. Like I know in my body, I know because of my clients, I know that it does not work. So one of the really cool things I think the RJ Council leaned into early on was system level change. How do we effectuate system level change? And in 2018, the RJ Council began what was a prosecutor, public defender RJ team. And I am the public defender on that RJ team. And so we've been charged with educating system-based lawyers, judges, victim advocates, probation officers, whomever, about restorative justice. Now, that has taken a lot of interesting turns with COVID and all these pieces, and we've learned essentially how to support a community that's requesting our support, right? So it's not coming in and taking over, but they're inviting us in to help them in the community reshape what's possible in terms of the community holding conflict and harm. And so we have some really cool examples that we've been working on around that, and then learning from what has existed in Colorado and how programs came to exist in Colorado in the past, and using that model to see how we can effectuate change in other jurisdictions and other communities across Colorado that may not have restorative justice programs yet. So an overview of Colorado, we have many amazing RJ programs, but they're scattershot across our state. We have rural jurisdictions, we have, cities and urban jurisdictions, and we have programs in both. But these programs that work in the rural jurisdictions may not necessarily work in the urban jurisdictions, sort of to Jessica's point from earlier. It has to be like really held by the community and envisioned and created and cultivated by that community to meet that community's needs. And what we were seeing in doing this is that there's not equitable access to restorative justice. If you have a community or a DA's office or a police department in your community that holds restorative justice, then you might have an opportunity to do restorative justice if you get through all the gatekeepers around the system pieces. The police have to refer the case, the DA has to refer the case. So when you have disparities, it's often a reflection of the gatekeepers in the system not allowing cases to go to restorative justice. Back to the access issue. So we were trying to figure out how to offer equitable statewide access. And I don't know that we have a solution exactly yet, but that's something we're working very hard towards, both with that prosecutor, public defender, restorative justice team, as well as practitioners in the state that are really committed to this. So yeah, we experienced in this sort of pilot program of this team, this RJ team, we experienced a lot of access to barriers to access, not just legal barriers, but also practical barriers. So, we have the concern around co-opting of restorative justice by the system and it no longer being really truly restorative, coercion, all the things that have been mentioned around legal problems that are just amplified if it is encompassed within the agency of the carceral system. So what we sort of did is gathered up all of these barriers that we were experiencing and trying to figure out solutions. And one of those solutions was the bill that Pete referred to around creating a right to restorative justice for victims and survivors around restorative justice. And I think that would have been really tremendous had we passed that. We were working on funding and some other solutions. All the problems that have been mentioned sort of today, we had a proposed solution in that bill around funding, around, access. Regardless, since that did not work out as we had hoped, we're not deterred, obviously. We got to figure out new solutions. So one thing that we have been using that I just want to offer in our limited time left is sort of using suitability assessments. So seeing if someone involved in this wants restorative justice, whether that's the person who was harmed, whether that's a system actor who thinks that this may be an okay case for restorative justice, these people might be interested. We use a suitability assessment. We have facilitators meet with, do sort of a pre-conference with the person who caused harm to see if they would be appropriate for restorative justice, so that we are assuring that if we continue down this path, that we're not setting up the survivor, for example, with believing that they might have this option and then it's taken away from them, for example. So in doing that work, we have also started creating a statewide network of facilitators in Colorado. Skilled facilitators who are willing to travel anywhere in the state to address individual harm cases. So when someone is seeking restorative justice, we can access the restorative justice facilitator network, so to speak, and engage those facilitators to respond to that individual personal harm and conflict, thereby eliminating some of the access barriers to, like, for example, getting access to a defendant who is in a jail. We had that problem recently where they didn't understand what restorative justice was at all. Despite the prosecutor being informed, the judge being informed, the defense attorney being informed, at the end of the day, one of our we do co-facilitation often in high impact cases, so, or always if possible. And, you know, it ended up being what was not necessarily the most restorative situation ever, with our, with the person who has caused harm in shackles in the courtroom, way spread apart from his, the surviving family members who wanted to meet with him. It was not ideal, and it still offered a lot of healing that would have not been available had the system not even allowed us to do that little bit, right? So it's about, like, trying to be as human-centered as possible in this carceral system. And I want to really echo, like, the national study around more than 50% of victims don't engage the system. If they're not engaging police, if they're not willing to go to the prosecutors, and understandably so, because of bone fear and things like that, fear of prosecution, fear of deportation, who knows, right? Fear of getting killed. We have to be honoring all of those people who are not able to find justice in our legal system. And I think we do that through restorative justice and transformative justice in our communities, offering them hubs and places to go to access restorative justice. So yeah, I really believe in community-centered restorative justice. And I think there is an opportunity for system players to be advocates in dismantling the systems of oppression that we have created in this country. So thank you very much for letting me share my perspective.
Thank you, Liz. Thank you for sharing. As you can see, we probably won't have time for a question and answer period, but we would just like to give a few minutes for our final speaker, Martha McLafferty, who's the executive director at the Hartford Community Restorative Justice Center in Vermont. And so after Martha shares her experiences, we'll have a quick poll, hopefully, that you all can fill out, and then we'll be closing. So without further ado, Martha, the floor is yours.
Thank you, Inc. It's wonderful to hear what's going on in New York and Colorado. So as mentioned, I'm the director of the Hartford Community Restorative Justice Center, which is in White River Junction, Vermont. And the Hartford Justice Center is one of 17 community-based justice centers in Vermont. And they all provide restorative justice-based programs that work towards enhancing community safety, increasing citizen participation in the criminal legal process, offering survivors voice and choice in the resolution process, and preventing incarceration and reincarceration. The development of these community justice centers began in 1998 when the Vermont Department of Corrections reached out to different municipalities throughout the state, met with community members and community stakeholders to create these justice centers, and with the hopes that they would provide restorative justice programs, offering accountability and support to people who cause harm while addressing the needs of survivors and the community. So the community justice centers serve program participants that span the criminal justice continuum, from resolving conflicts before a crime occurs to providing transitional housing and reintegration services for people returning from incarceration, and all points in between. And the use of restorative justice is codified in Vermont law, statute title 28. It's the policy of the state that principles of restorative justice be included in shaping how the criminal justice system responds to persons charged with or convicted of criminal offenses. So I won't go into details about some of the programs. We have a restorative justice panels, which where people have caused harm meet with trained community volunteers, any survivors or affected parties who choose to participate. And so they take responsibility for the harm, understand the impact, of their actions on survivors in the community, determine ways they can make amends to those they've harmed, think about how they can prevent future reoffense. And just thinking a lot about how the importance of having these restorative justice processes based in the community. One of the new programs we have in our local community is to work with men convicted of misdemeanor domestic violence. And it was a collaboratively designed program with our state's attorney and probation and parole and our victims advocacy agency. And through that process, we've been able to create a restorative justice program for people convicted of domestic violence. So I think I'll stop there, but thank you very much for the opportunity.
Thank you so much, Martha. So as you can see, yeah, we are a bit running over time, but I think we might be having a poll going out just really quickly. Yep, there it is. And then after that, that's it from our speakers. And so that'll be it from me and Asadeepan. So thank you so much for your time, your interest, and hopefully very shortly your work around this issue. Thanks, everyone.